Happy Wednesday. It is Why with One Stop, and I am Sam Hayes. Today we are talking about notice to performs versus demand to close escrow. What's the difference? What's the big deal? When do you use which one? What does it do? All that fun stuff. I've been doing this for over 2 decades, about 7,000 transactions. I'm risk management focused TC, a car certified transaction coordinator, forms trainer, realtor, notary. I just love the stuff, and I always have some adventure on Zoom no matter what when I'm presenting. So it's always a little bit of fun. My mission statement and what I'm all about is my objective is to create a defendable risk management focused and well documented file in compliance with DRE, broker, and statutory requirements. Through the services that I offer, I provide additional bandwidth to the agents and brokers I assist by freeing up their time and energy to focus on pursuing their business generation goals. So I'm here to take some stuff off your plate so you can go do what you love, so I get to do what I love. All right, so what's a notice? A notice is letting somebody know. It's a notification or a warning. It's a notice about it. And it's to let preparations, it's to let things happen. It's like, hey, warning sign. Hey, we need to do this. What's going on? What is a notice to perform? So in the contract, there are different pieces of contractual action and administrative items that are agreed to mutually when you sign the contract, stating, hey, if something comes up, we have a bump in the road, there's a slight problem, we get to say, look, what's going on? You need to do this. You need to stay within time frames. If somebody's kind of going out of bounds and veering off of time frames, hey, let's get it together. Come on. It is a contractually agreed upon option. That's it. That's all a notice to perform is it is a documentation process to administrate what was agreed upon in the contract and stay within time frames. It's not an insult. I have seen more agents. Oh my God, can you believe? Oh my God, they sent me. Okay, they didn't send you. They sent the other party on behalf of the other party a notice to comply with time frames. That's it. And it's a fiduciary act that they're doing by staying on those time frames, servicing their client, and making sure they're documenting that they've administered the terms of the contract that they're supposed to be helping execute. That's it. It's not a terrible thing. It's a reality check of, hey, we're off the rails, we're out of time frames, let's get back on board. That's all it is. It's not a judgment about well, they can't believe I'm not getting it done. I can't believe they judge me, and how dare they? Nobody's judging you as an agent. That's not what it is. Obviously, something happened. It may be out of your control. You may have a client who's not understanding the time frames. You may have lending. You may have some inspections that are out of bounds. All those things. It happens. It is not a judgment on you as an agent. It's not something where you, as the agent, also can just go, I'm sending a notice to perform. You're not party of the contract. You don't get to do that. If your client wants to, you do want to review that portion of the contract where it explains the notice to perform, the ramification, and potential pitfalls, and also the benefits. That is all it is. It is just a part of the contract. It's a contractual action that can be taken to remedy time frame situations and get things done and stay moving forward. That's it. It's not that big a deal. So, what is the notice to perform? Well, in RPA 14E, this states that is for the notice to the buyer or the seller, because the buyer can notice the seller, it's got to be in writing. It's got to be signed by that applicable party. So that's why agents, you don't get to go, hey, no. And it must be given to the other party at least 2 days prior to or after delivery or until the the time specified in the applicable paragraph. So if you've got a contingency removal coming up and it's Tuesday and you're freaking out, you don't get to send it till Wednesday. You can only send it 2 days. And our contractual terms in RPA 25E, I believe it is, explain what days are. That definition is defined in the contract. And days go to 11:59 p.m., by the way. So this is just a thing to get everybody back on track saying, hey, you need to notice to perform. You can send it 2 days prior. Some business models, that's what they do because that's when they want to have it ready. It's not an attack. It's staying with the terms of the contract. The other issue with this, though, is you got to make sure you know what you're noticing about. What's going on? Do you have it correct? Do you have your time frames correct? You can't arbitrarily decide to make it one day. You can't arbitrarily decide you've got to notice it within an hour. That's not how this works. It is 2 days in the contract. Those of us that are old school remember when it used to be, it went from hours to days. or what, excuse me, from days to hours. And then I was having people write in 72 days when they used to write in 72 hours. So we had that not getting caught all the time. That's fun when you've got a 30-day escrow and you've got a 72-day notice to perform. Little things about this, you need to pay attention to the nitty-gritty. So they made it a permanent when they updated the contract several years ago. It's 2 days. You don't get to change that. You can give them more time, but you cannot give them less than 2 days. And those are calendar days. You also cannot demand performance if that falls on Saturday or Sunday or a holiday. You cannot demand performance till the next business day, and they have till 11:59 of that day per the contract, like we were just saying, day's definition, to perform. So pay attention. Today, if I was to send a notice to perform on a Wednesday, today is day 0. They would have till Friday at 11:59 to go ahead and get everything through. But then how am I going to get proof of that? So I'm still not going to have till Monday for pushing it. You can try and cancel escrow over a weekend if you get an escrow that's around. If you want to cancel, usually it's best to have a great communication with your other agent that you're working with. Find out what's going on. Things happen, delays happen. Conflict arises when expectations differ. If we can communicate between each other and have a setup of like, we got disclosure to you a little late. We understand we need to give you a little bit more time. You need more time to investigate because weather, since it's randomly raining here in San Diego today, you never know. Keep that communication flowing, but understand this is a document to help document the contract for compliance. This is a document to help make it easier on everybody to know, here's our paper trail, here's what happened. So we all have kind of a map if we ever have to go back and figure things out. Now, if you for some reason missed anything on there, just again, whichever ones are not in compliance, say you ask for the loan contingency, but it's really not due for 3 days, then you just resend it for the loan. Everything else that's applicable will still apply. That was one of the updates they did to the form and the contract in December to make sure, because everybody's having to redo the notices. I had one where we had to renotice and renotice because there was always something just slightly off. So make sure you take a few moments, double check all of your time frames, double check your contract before you send one of these over, review it with your client as well to make sure they understand this now means that, cancellation is available. That's the potential. This could mean deposit may be at risk if some of the contingencies are removed, but typically this is sent when none of the contingencies have been removed and we've got outstanding items to do. Let's take a look at the form because it is a little bit different between the buyer version and the seller version. So there's two parts to this. We have contingencies and then we'll have contractual actions that we'll go into. Contingencies, you can have all of them. You have all the different little pieces. There might be a contingency that was written into your contract. Always verify with the broker of record of the file you're working on anytime you're adding verbiage, of course, always, because that whole practicing legal thing, that was a video a few weeks ago that you can go back and watch. It can be in, did you remove for the HOA? Did you go through the solar? Did you enter into your COP? Did you close escrow on your COP? Have you investigated? Do you have insurance? Did you look at all the disclosures? Did you look at the prelim? What about your loan? What about your appraisal? So you can notice on one, many, or all by marking the box above. Then there are actual contractual actions. Well, what if the deposit hasn't been received? Or we need to increase the deposit, or you were supposed to sign the liquidated damages clause. Did you change out your lender and you need to update us and let us know the contact info? What are the requirements for the FHA VA? Do we have proof of your funds? Do we have proof that you actually applied for the loan that you said you were going to? Are you going to assume or accept these leases for the solar, the water heater, the propane, the well? Who knows? Did you give back the disclosures? You have to give them back. That's in the contract to give them back. Did you return the lead disclosure, specifically the FHDS, because the home hardening is its own civil code issue? Have you complied with title's efforts? Did you deliver the proof that the assignee, what if you're signing the contract? Well, I need to know that the new assignee can actually pay for all this that you've given. I need proof. Give me that from the lender. Do you have the authority to act? That's a big one. I circle back and everybody's like, oh, you'll get it from escrow. Oh, you'll get it. No, that's supposed to be delivered by the party who's signing on behalf of the entity to the other party within 3 days of opening escrow. That gets missed all the time. This pushing it off on escrow, this is a soapbox I will never get off of. It's really important. We need to have that documentation. So if you're working with anybody who's an entity, get that before you're writing a contract. Get that before we're under escrow. Make your life easier. Do we have proof that you've gotten the other COP into escrow? Do we have proof that this is really happening? Did you actually list it? Did it go on the market? Did you remove those contingencies? Has that stepped over? These are all different things. And then contractual action on that. You can also go into anything that you've written in. Maybe there's a certain term that you agreed to. Maybe there was something else you were investigating. Maybe there was something about an ADU that can be also written into DD to make sure that you've got all the documents for it. But there's two parts of that notice to perform. So remember, you can have both your contingencies, but you can also notice on contractual actions. It's a big thing to remember. It's more so the contractual actions with the seller that will go into that form next. And then there's also your time frame. 2 days is the default. You can give more, but not less. Definitely give more room. So you want to document all of that. And it needs to be signed by a party to the contract who's noticing the other party to the contract. This is not the agents. This is not by phone. This is not signature on file. All the weird stuff that used to happen back in the day. None of that is what's going on anymore now. So with the seller, as we were talking about, it's more contractual actions. Like I need to know let me see your leases. I've got to review this. Can I assume this? Am I talking to him? I've got to go through credit checks and things to make sure I can do that. Did you give me all the disclosures that you're required to give me? And if somebody's saying, well, I don't have to, or we're not going to, check with your broker of record. It may be good to go ahead that you did notice the seller to perform. You did give them the option. And then I would probably also do going against broker advice letter, but that's a whole other thing. I need to have fully completed lead disclosure. I need to know about the home hardening. Now, remember, we just got updated maps last week. Double check. My house suddenly went from no fire to super high fire. I have had two escrows that have had to go back. We've got to get new updated maps because of what's going on. Make sure you're double checking. Make sure you're checking those maps. Talk to your NHD company. Call and find out about the reports to verify. You want to make sure because that FHDS is a civil code TDS level disclosure. Make sure you're covering your butt. And if they're not saying they don't have to do it, send them one of these. So at least you're documented that you did take the steps in the file after verifying with your broker of record. Where are your HOA docs? Did you get all your booklets? People are saying, well, the links are fine. I have an issue about that too. I got to say, totally soapboxing and taking a cul-de-sac moment here, but the law says booklets. The law does not say links. And many of the links are actually broken or don't work. It's always best practice to be over conservative versus under. I always send the booklets. Make sure even if they send you a link, if you've got copies of the booklets and they won't send them something that's been documented for your file, check with that broker. Did you get the prelim? Do we have proof that you can act on that capacity? All the times of having sellers say, oh, well, get it from escrow. You'll get it from escrow. You'll get it from escrow. I've had it happen a few times where the wrong people or not enough people were signing on behalf of the entities. Double check that. That's a problem that could cause a cloud on title. We could have something that was undisclosed. That's a whole can of worms you don't want to go into for saying, well, I don't want to bother them. Bother. We're supposed to bother. We are bothering because we're trying to help somebody do one of the most major life-changing purchases of their life. It's time to bother. Get all the right information. And it always falls more on the buyer's agent for helping to assist the buyer for getting the information than it does on the seller's agent. Goes into a whole thing there. Delivery of the following inspection or report. Were they supposed to have a termite report done, a sewer, a septic, a well, propane, roof? Maybe there's something with the HOA. Who knows? Get a copy of that report. Are there any other disclosures and deliveries that were promised that were negotiated in the contract that were going to be given? Is there something about the leases for any tenants? Do we have any other disclosures about an agreement with the neighbor? Is there an unrecorded easement agreement? Any of that type of stuff. Remove your property. Sellers are supposed to take their property. This is saying, hey, you need to remove that prior to close of escrow. You said you would clear it out. You can do it there. You can also add what other terms you need to into anything that's specific to your contract. But again, verify that with your broker of record because adding things is practicing law. Sellers typically only have two contingencies. That's when we have the seller property replacement property. One is when they find it. So if they've already found it and they're in escrow before we open the escrow of their property that they're selling to buy the up leg, then you're fine because that gets removed with showing proof of that. The other one is then removal that they've closed on that property. If that's one of the terms, maybe they're having to do rent back or some sort of balance. Typically, they're going to have done that right after. They're going to want to go concurrent because of funding issues, but find out. You may have another contingency written in that there's some verification or something like that. Find out, but you can notice them. Buyers can notice as sellers to perform. I think that's something people forget when they're like, well, the seller won't do it. Document it. Make sure you're building your file. If this goes to court, we want to defend. You took all of the tools and took advantage of them for your best fiduciary to your client. So we've had a notice. We've noticed. We've told you, hey, get this together. Typically, you haven't removed all contingencies or you haven't taken an action. I'm noticing you. Get it together. We're still trying to keep this going. Demand is insistent. It's peremptory. It's saying, look, you need to do this. We agreed. Typically, you're not going to do your demand to close escrow until all your contingencies are removed, all the disclosures have been returned. We've got all the inspections on file. We're just waiting. Maybe a loan's taking a little bit longer, maybe some change on some lenders, maybe there might be change in financing, trying to sign it. Who knows? This is usually a demand you're thinking is at the end. Like, I am demanding we close this. I have done all my stuff. I'm done. You have no wiggle room. We've removed the contingencies. Do it. Just let's close the escrow. That's the difference between the two. Notice is like, hey, I need these contingency removals. I need my stuff. Demand is, why aren't we closed? We're all done. What's going on? So think of it in those terms because I'll have people say, well, I want a demand. Well, no, you're not doing a demand. We need to notice and make sure you look at the file first because a demand, you have more of a likelihood of a shot at deposit. We never speak and say 100% anybody gets to keep the deposit. That's something that would be decided by courts and other things. But there's more substantiary evidence of like, hey, we did everything. There's no reason they shouldn't get to keep the deposit. Where you're noticed to perform, there's obviously a contingency or something typically that's outstanding, which would leave wiggle room for the deposit to be returned to the other party. Demand to close escrow is pretty simple form. It's either the seller's demanding or the buyer's demanding. It's a 3-day situation. You can do it no less than 3 days specified. You can send it 3 days prior to, but it's got to be following on that third day. So if we're closing on the 30th, then you could notice on, I would do the 28th to be a little conservative, but you could do the 27th, but then you could end up with people wiggling and fighting. So I'd probably do it within on the 28th because then you've got 28th, 29th, 30th. But then we get into day counting and people get into fights, which is another video I'll have up in May to go through and explain what the contract says. And then we know how it gets interpreted sometimes. But it's very basic. And you're just saying, look, you're under demand to close escrow. This is when we said we'd close escrow. I want to close escrow. Let's close escrow. The end. And then from there, you're going into where you might have to go to mediation, arbitration based on how you've set up the contract, lawyers, all of that fun stuff. But that's where our next steps are. So which do I do when, Sam? As we were talking about, are those contingencies removed? If they're not, you're going to do a notice to perform. You're going to notice them if the full CR, if something's not delivered, something hasn't arrived, something hasn't been, be your contingencies, your supporting documentation, whatever, that's what we need. Typically the full contingency removal is not on file. So that's why we're noticing you. And potentially, usually you're not going to be keeping the deposit. Each individual one, verify with your broker of record, everything else. But typically that's a like, hey, we're halfway through the escrow. You're not performing. Goodbye. We're done. Now, a demand to close escrow is we have gotten to the point where escrow is done. Everything's done. Why aren't we closing? Where's the money? What's going on? Usually all contingencies are removed. Everything's been returned. There is more potential that you might get to keep the deposit. However, I am not a lawyer. Verify all with the broker of record of the file you're working on. Make sure you've got all that info. I hope that helps kind of clarify it a little bit. So again, you're noticing we're trying to get somebody to help, demanding, we're done. Let's get it over with. Easy peasy. So coming up next week, we're going to talk about the LBSB. What's that? That's the loan broker, sales broker, and the 24-hour rule. If the broker of record is the same for both the lender and the sales representative, doesn't have to be the same agent, but the broker overall, there's a time frame that everything has to be disclosed and delivered. Then we're going to get 16th, going to go into solar and the RLA and the RPA. Who's responsible for what? What are the time frames? What should we be getting? I know I've had several deals lately that it's just been crazy making and trying to learn what's better every time. I know there've been a lot of bankruptcies and different things with the changes of those companies. So I'm going to pull from all the experiences I've had lately. I'm definitely looking forward to hear some comments about what you've experienced and then what problems you've seen. April 23rd, escrow and lender versus timelines. I know escrow and the lender have their own clocks and how they're asking for things, but there is also due dates and timeframes in the contract that don't always match up. And managing expectations of when things have to contractually be returned versus, well, the lender needs this right now, escrow needs this right now. How do we work on that? How do we manage everybody's expectations and get those timeframes and get in alignment so make it much easier on all of us? And then, of course, end of the month, what all went wrong? How do we fix it? What was an adventure? I've already got a couple of really good ones that I've been taking notes on. So it should be a doozy. And I hope you can always join me on Wednesdays at 12:30, or the replays will be up on YouTube. And as always, thank you so much for joining me. I am available for questions anytime, even if I'm not the TC on the file. Feel free to give me a call. Please like, subscribe, surprise. You can surprise, subscribe and follow. I also have things on my Facebook page. I'm on LinkedIn. Who knows, whatever is the appropriate social media of the week. It's always changing, but I'm here. I'm happy to help. Thanks so much for joining me. Again, I'm Sam Hayes. This was Why with One Stop, talking about notice to perform versus demand to close escrow. As always, verify everything with the broker of the record of the file you're working on. I will see you next week and look forward to it. Have a great day.